Arbitration Center. I'm pleased to extend a warm welcome to our speaker for today, Mr. Kirandeep Singh. Singh, Senior Partner, Dentons Rodex, Singapore. Mr. Ganesh Chandru, Partner, Dua Associates. Ms. Saraswati is there, and Ms. Madhuri, Advocate, T.S. Gopalan and Co. The Governing Council members, the General Committee members, and all the participants for the 15th session in the arbitration series. Most of you are members of the Chamber, and you're aware that the Chamber is in 186th year of service to trade and commerce. The Chamber is one of the first few organizations to provide arbitration services for resolving commercial disputes from the year 2000. Based on the request of some of our members, the Chamber had established an exclusive MCCI Arbitration Mediation and Conciliation Center, MAMC in short, for the benefit of our members. We had a formal virtual ceremony in January 2021, wherein Honorable Justice Mr. Sanjay Kishan Kaur, Judge, Supreme Court of India, inaugurated the center's new premises virtually. The center has the state-of-the-art facilities and is on our own premises opposite to our office at Karamuthu Center, Anna Salai. It has 3 arbitration rooms and a discussion room. I'm requesting my colleague to show you a 2-minute video of our center. Jaya, can you please do it? Thank you. I'd like to add that one of the main objectives of the center is to promote quick, cost-effective, transparent arbitration, mediation, and conciliation services. We have experts in its governing council to guide the affairs of the center, and we have an eminent panel of arbitrators. The governing council functions with the guidance provided by the General Committee of the Chamber. If you want to know more details, you can definitely be in touch with us. As for today's session, I would like to add that this is the topic is public policy as a ground to set aside and resist enforcement of arbitral awards, a comparative perspective. I'm requesting Mr. Ganesh Chandru, the moderator of the session, to introduce the speaker and topic to the participants. Ms. Madhuri will formally propose the vote of thanks. Thank you, Mr. Kirandeep Singh, for joining us today. Over to you, Ganesh. Thank you.
Thank you, Madhu. It's indeed a pleasure to be here this evening and to introduce my dear friend and former colleague. I used to be at the same firm as Kiran in Singapore. Kirandeep Singh is a senior partner with Dentons, Rodex, and Davidson's Litigation and Dispute Resolution and Arbitration Practice Group. He's the co-head of the firm's construction and international trade practices. For those who already probably do not know, Dentons is now the world's largest law firm as to the number of offices. It's the biggest in the world, and Rodeck and Davidson is the oldest law firm in Singapore, and it joined with Dentons a few years ago. Kiran practices primarily in the area of construction engineering and arbitration, general civil and commercial litigation. Insofar as construction and engineering is concerned, he has been involved in numerous disputes involving adjudication, dispute boards, arbitration and litigation, both as counsel as well as adjudicator and arbitrator. Besides advising local clients in various disputes before the courts in Singapore and at arbitration, Kiran has been involved in various international and regional matters, dispute boards, and commercial arbitration, including those in ASEAN countries and various countries in Asia, Africa, Europe, America. He speaks regularly at seminars and conferences, and he is named as a leading individual for construction by Chambers Asia Pacific since 2021. More than anything, Kiran's roots are in India and Punjab, and we are very happy, Kiran, to have you here today. On behalf of all of us in Chennai and other places in the Madras Chamber, I welcome you to speak on this interesting topic of public policy, which we all know is often used to as a weapon in the armory of a litigation or arbitration lawyer to try and set aside award or resist enforcement of awards. Of course, they say it's an unruly horse, but let's see from your presentation whether this unruly horse can be tamed. Over to you.
Thank you, Ganesh. Thank you. Let me just begin by sharing the slides. Yes. Ganesh, thanks for the introduction. And yes, my roots are in India, although I was born in Singapore. And like I mentioned to you, I look forward to speaking in person in India instead of over Zoom in future. The good news is Singapore today, our Prime Minister announced further opening up of Singapore. So hopefully we are back on track, getting back to.
Yes, that's great news. I just saw that. Yeah.
Yes. Okay, let's get on with the business for tonight then. Yeah, and as Madhu has mentioned the topic, it is public policy as a ground to set aside and resist enforcement of arbitral awards. And we will be looking at a comparative perspective. That means we'll be looking at arbitral decisions of the courts from various jurisdictions. We will look at India first, followed by Singapore, and then we will look at the decision of the UK Privy Council, and then we will move on to Hong Kong and end with Australia. And let's see whether or not this unruly horse has actually been tamed. Now, the public policy ground for setting aside of arbitration awards is embedded in the New York Convention and the Arbitral Model Law, Article 5(2)(b) of the New York Convention and Article 34(2)(b)(2) of the Arbitral Model Law. Now, many states have adopted the provisions of these international instruments in their national arbitration legislation, Singapore being one of them, and India also has adopted many grounds, also the public policy ground. Now, public policy is a nebulous concept. I think many of you familiar with arbitration would be familiar with the fact that public policy has in the past been used as like a ground to look into the merits of an award, because it's such a nebulous concept and many jurisdictions don't define what public policy is within their legislation. So it's largely, the definitions are largely a creature of case law. So public policy is a nebulous concept, and if it's not applied properly, it will conflict with the finality of arbitration. And that is what was said as far back as 1824 by Justice Barrow, right? This term unruly horse was coined by him. And he said public policy is a very unruly horse. And once you get astride it, you never know where it will carry you, right? Now, if you look at the preparatory materials for the New York Convention, if you look at all the discussions, etc., the concept of public policy was meant to be not of a political stance or equated to international policies of a state, right? It's not supposed to be unique to a country. It was meant to be a more limited concept that incorporated fundamental notions and principles of justice with an international dimension. So to put it simply, you're looking at international public policy. right? When considering whether to set aside an award on the grounds of public policy, you're looking at international public policy, and whether or not that fundamental notions and principles of justice of an international nature have been offended. Now, this is the observation from, two cases I've cited below, TCL Air Conditioner and PT Asuranasi and Dexia. One is a decision of the Federal Court of Australia, which we'll look at near the end of the presentation, and then the other one is a Singapore Court of Appeal decision, which I note has also been referred extensively by some Indian decisions, namely the Sanyong decision that we'll be looking at later. Now, approach of national courts. So courts in arbitration-friendly jurisdictions. Their approach to public policy exceptions is a very narrow one, right? It's one which encourages minimal trivial intervention. So the weight of authority in these arbitral-friendly jurisdictions is to give a very narrow meaning when it comes to a breach of public policy. Now, errors of fact and law will not automatically result in setting aside the award. So to put it very bluntly, you've chosen arbitration. If the point of law has been considered by the arbitrator, if the facts have been considered by the arbitrator, and is properly reasoned in the award, even if it may be wrong, the bad news is most of the time you are stuck with it, right? You cannot set aside the award on the basis that there's a breach of public policy because, and this is the approach of arbitral-friendly jurisdictions, you cannot set aside the award on the grounds that there was a wrong application of the law, wrong application of the fact, that it's a breach of public policy, and the award should be set aside. So the threshold to satisfy when the court is looking at public policy as an alleged ground to set aside an award, the term that has been coined is it must shock the conscience of the court, right? It must shock the conscience of the court. It must be something that is injurious to the public good, something that is wholly offensive to the ordinary, reasonable, and fully informed member of public. It must violate your notion of morality and justice, right? That's what public policy, a breach of public policy is. So it must shock the conscience. And this term, shock the conscience, has been used in several cases around the world, including Associate Builders and DDA, the Supreme Court of India decision in 2015, Court of Appeal in Singapore, the Persero and Dexia Bank decision in 2006, and also the Hong Kong Court of Final Appeal in Hebei Import and Polytech Engineering. So this is the approach that arbitration-friendly jurisdictions take to when it comes to applications to set aside or resist enforcement of awards on the basis of a breach of public policy. Now let's begin to look at some of the cases. And many of you are, of course, very familiar with this line of cases, and I may be preaching to the converted as such, or actually speaking to people who may know, people who definitely know much more about this area than myself. But I'm just summarizing the Indian position. I mean, we all know that India started off by giving a very wide approach to the conception of public policy. And that's mainly in two ONGC decisions, coincidentally, ONGC and SAW Pipes, and ONGC and Western Gecko. Now, we know in the 2003 decision of ONGC and SAW Pipes, there was a significant shift by the Indian courts towards a wider conception of public policy. And in SAW Pipes, very familiar now, and of course very current before 2015, there was a lot of debate about this. The Supreme Court there held that an award could be in conflict with public policy if there was patent illegality. And the unique thing about that decision is patent illegality meant if there was a patent violation or wrongful application of Indian law, that would be something that was in breach of Indian public policy, right? So in that case, violation of statutory provisions was held not to be in the public interest. And the decision of ONGC and SAW Pipes was followed about 10 over years later in another Supreme Court decision of ONGC and Western Gecko. And there what the court did is when interpreting the meaning of of public policy and how the courts should approach applications to set aside awards on the basis of public policy. The court applied the Wednesbury principle of reasonableness. Right? Basically, the court held that any court hearing a setting aside application should adopt a judicial approach. Now, that's quite shocking. They say that a judicial approach, right? And declined to uphold an arbitral award which was so perverse or irrational that no reasonable person would have arrived at that decision. So an award could be set aside if there was an inference which should not have been made, or an inference which should have been made, or a prima facie wrong inference. So if the tribunal made the wrong inference or didn't make an inference that it should have been made, that award could be set aside. Now, adopting this approach, the Supreme Court then modified the quantum of damages in that case and awarded and allowed the deduction of liquidated damages, contrary to the decision reached by the tribunal. Now, these two decisions were heavily criticized, as we know, heavily criticized by many academics and many lawyers as well. And this resulted in the Law Commission of India report. And the Law Commission opined that these decisions, ONGC, these two decisions could open the floodgates for judicial intervention in arbitrations. And they took the view that it could affect India's development as a destination for commercial arbitration. And not only that, it would encourage challenging awards, and this could lead to a backlog of cases in the court system. I mean, there's a huge backlog already. There was already a huge backlog in India in those days, and this could add to the backlog. So changes were proposed, and amendments were then adopted in the Arbitration and Conciliation Act 1996, and those changes came into effect in 2015. Now, a very brief look at the changes that were implemented, and these were, as you will know, implemented by way of explanations to the relevant sections in the Arbitration and Conciliation Act. You have Section 34, which has to do with applications to set aside awards, and you have also Section 48, which has to do with applications to enforce the awards. Now, looking at the explanation to Section 34(2)(b), which provides the ground for setting aside for breach of public policy. The explanation 1 to Section 34(b) provided definitions of what could constitute a breach of public policy. And there the definitions were fraud or corruption, anything affected by fraud or corruption, an award which contravened provisions on confidentiality, or the use of evidence in other proceedings, where there was a contravention of fundamental policy of Indian law, and where the award conflicted with India's most basic notions of morality and justice. And explanation 2 further elaborated on that and says that any decision to set aside an award for breach of public policy should not entail a review on the merits of the dispute. And that's very important. It cannot review the merits of the dispute. And then explanation 2A retained the test of patent illegality, but that was restricted to domestic awards. So the Law Commission recognized there could be a greater scope for review when it comes to domestic arbitration awards. But even then, the scope of patent illegality would be more restricted as compared to the approach that the Supreme Court adopted in Sawpies. So, the explanation states that an award cannot be set aside for patent illegality merely because there has been erroneous application of the law. The court also shouldn't engage in reappreciation of evidence. Now, so this largely mirrored what in Law Commission report, most of you would be familiar with it, referred to an earlier decision of the Indian courts in Renu Sagar, right? So the Supreme Court of India then had the opportunity to interpret these amendments in the decision of Sanyong Engineering and National Highways Authority. There it looked at Sawpies and Western Gecko. It held that these cases were no longer applicable. And instead, the court in Sanyong Engineering, the Supreme Court, held that Indian public policy was to be interpreted in line with Renu Sagar Power and General Electric, right? A case dating back as far as 1994. And there it was held that there should be a contravention. If there's going to be a breach of a public policy, there should be a contravention of a law protecting national interests, or where superior or orders of the superior courts of India were disregarded, or principles of natural justice such as audi alterum partem have been ignored, right? Where maybe one party has not had the chance to present its case on a particular issue. And the Supreme Court refused there, in this case, in Sanyong Engineering, to accept an award which violated Indian law, right? By awarding compound interest should be set aside. No, sorry, Renu Sagar, that an award which violated Indian law by awarding compound interest should be set aside on public policy grounds, right? So, in that case, as far back as 1994, the Supreme Court refused to accept that even if Indian public policy was wrongly applied, Indian law was wrongly applied, and an award, there was an award for with compound interest, it could not be set aside on public policy grounds. So the court reiterated that it must shock the conscience. So patent illegality cannot just be an erroneous application of the law. And this is something that I think I want you to take back from today's talk is, as long as the law is considered, as long as the tribunal has given parties a chance to submit on the law, as long as they have considered the law, considered the facts, have provided a reasoned award on the law and on the facts, even if they arrive at a wrong decision, that is not grounds to set aside on the basis of public policy. And this is something that I'm sure many of those who are practitioners here would know that it is something that we always have to emphasize to clients. We always have to tell clients, look, this is arbitration for you. The arbitrators may apply the law wrongly. They may apply the facts wrong, but that's not a ground to set aside the award, right? Now, very briefly, in Sanyong, a dispute arose between the parties for the construction of a 4-lane bypass on the national highway in the state of Madhya Pradesh. And Sanyong Engineering was to be compensated under the contract for inflation in prices of components to be used in construction of the highway. So there was a index that was to be applied for them to be reimbursed for inflation because of an increase in the price of components. And that was the wholesale price index following 1993 and 1924 as the base year. But however, subsequently, the National Highways Authority, they issued a new circular and revising the wholesale price index to follow 2004 to 2005 as the base year for calculating the cost of inflation. So I'm sure the inflation would have been much higher if you calculated it from 1983 to 1994 as opposed to 2004 and 2005. And Sanyong Engineering actually challenged the applicability of the later circular, saying that it's not part of the contract, right? So Sanyong argued this is not part of the contract. We have not agreed to this circular being applied, and that the tribunal should apply the earlier circular, the earlier index, the wholesale price index. They should apply that index where the base year would be 1993 to 1994. Now, there was a split decision. The majority of the tribunal decided that the revision of the wholesale price index and the adoption of the 2004 to 2005 as the base year, that was within the terms of the contract, while the minority decided otherwise. So Sanyong applied to set aside the majority award on the ground that it contravenes Indian public policy. And the Supreme Court agreed. They set aside the majority award and upheld the minority award. Now, why did the Supreme Court of India do that? The court found that parties were able, firstly, they were able to continue to use the original wholesale price index, despite the issuance of a new index. But more importantly, the majority's decision, they felt, created a new contract. Because what the majority did is that they said that they referred to some website extract and they said that, well, and this website was not even something that parties had a chance to submit upon this guideline on a website. The majority actually utilized that guideline and said that, well, the new index, the updated index was applicable. The court said that parties didn't have the chance to submit on that. And this circular itself required the consent of SsangYong. SsangYong hadn't given consent to the applicability of this index. So the majority's decision, the Supreme Court held, created a new contract for the parties by substituting a workable formula under the agreement, which parties had agreed to, with use of a unilateral circular deholds the agreement. That means without the consent of the other party, that circular was applied. And this was making a unilateral change to the contract. The court felt and the court held that this was a breach of the fundamental principle of justice. It shocked the conscience. It was a unilateral decision or a unilateral alteration of the contract by the tribunal itself. So the tribunal was foisting a unilateral alteration upon an unwilling party. And that was a breach of public policy. It shocked the conscience. So that's India for you. Now let's move on quickly to Singapore. Now in Singapore, let's look at this case of BAZ versus BBA. Now this concerned a share purchase and share subscription agreement. And it involved an Indian company. An Indian company purchased, the buyers purchased shares in an Indian company that were held by the sellers, and some of the sellers were minors. Now, there was a breach of this agreement, the award, the share purchase and share subscription agreement, and the award provided that the sellers and the minors were jointly and severally liable to the buyers. Now, again, the majority of the tribunal, there was again a split decision. The majority found that the sellers were liable for fraudulently misrepresenting and concealing the genesis, nature, and severity of certain regulatory breaches as disclosed in a self-assessment report. So this self-assessment report, as it wasn't disclosed, it had a material effect on the agreement, on the share price, etc., and on the decision whether or not to purchase the shares. Now, the minority, the minors, right? The minors in this case, as some of the sellers were also minors, right? Minors being not of majority, not over 21, right? Or over 18, depending where you are from. The minors' application to set aside the award against them succeeded on the basis that the award violated substantial protection of minors. So here the Singapore court said, look, wait a minute. How can you have an award against minors? How can you have an award against minors and hold them to be liable for the fraudulent misrepresentation on the part of their guardians or principals? That is, and there was no justification, there were no exceptions, right? There are certain exceptions under Singapore law when you can hold minors liable, like for example, sale of necessities or something like that, right? But the court held that the effect of the award was to enforce the share purchase and share subscription agreement, which wasn't a contract falling under any of the exceptions under Singapore law to the general position that contracts do not bind minors. So it did not fall within any of the exceptions. It imposed liability on them for fraud, which had been committed by the guardians or the principals. And the court held that this violated protection given to minors under Section 35(7) of the Civil Law Act. It shocked the conscience. It imposed substantial liability, right? I mean, you can think about this. It's ridiculous. It imposed substantial liability on minors who were 3 to 12 years old at the material time. So this shocked the conscience of the court, and the award, insofar as it was applicable to the minors, that part of the award was set aside. Right, so that's the case of BAZ and BBA for you. Now let's quickly go to the next case, another Singapore case, CEB and CEC. Right, all these because of confidentiality reasons, you don't have the full name of the parties in the reports. So this involved again an Indian claimant. Matter involved two arbitration claims brought by an Indian claimant against a UAE company, companies CEC and CEE, and it concerned the sale and purchase agreements for commodities, sale and purchase agreements for edible oils and other commodities. Now, what happened is the UAE company, the respondents, the companies failed to pay for commodities supplied, and what the claimant did, what the Indian claimant did, was they terminated all of the contracts, right? They not only terminated the contracts that had not been performed, but they terminated the contracts that were yet to be performed. So they took it as an anticipatory breach, right? They argued that, look, since you have not paid me under these contracts, contracts say A and B, right? I take it as an anticipatory breach of contracts C and D. So they terminated all of the contracts and they brought arbitration proceedings against the UAE companies. Now, the claimant, the Indian company here, was successful in its principal claim, but in the end, they hardly got anything. They didn't get anything. The arbitrator did not make any award of damages for consequential losses. And why did our arbitrator not do that? Because the respondents, the UAE companies, brought a counterclaim. And the counterclaim was for wrongful termination of the unperformed contracts. They were saying these contracts are all separable, right? We have a few contracts. Yes, one or two we have not paid, right? But the rest, the time for payment has not arrived. The time for performing our obligations has not arrived, and you have terminated those contracts, and you have done so unlawfully. And the arbitrator agreed and said, yes, there was unlawful termination, awarded the respondents damages, and set off that amount against what was due to the claimants under the contracts that were lawfully terminated. And so the damages cancelled out each other, right? Now, the claimants were not happy and they applied to the Singapore International Commercial Court to set aside the award on the ground that it was contrary to Singapore public policy of Singapore. They said that the arbitrator's decision erred in law, right? So it's an argument that it erred in law. They permitted the respondents to bring counterclaims and to recover losses by reasons of the claimant's termination of unperformed contracts. And they said that the financial consequences were just not acceptable. The financial consequences were so manifestly unjust that it shocked the conscience of the court. Now, the court disagreed. They rejected his arguments on public policy, and they noted that the claimant had found that the arbitrator, they looked at the award and they said the arbitrator had found that each contract was separate, right? So those which had been performed by the claimant and those which remained unperformed and were cancelled, right? They were all independent contracts. So I mean, those have been so there were a number of contracts, some of which had been breached and some and the rest had not been breached. They were all independent contracts. So since the arbitrator found that there was separate contracts, it was a necessary conclusion that the failure by one party to perform one of the contracts, example, by failing to pay the sum due under that contract, did not amount to an anticipatory breach of the other contracts, entitling the claimant to rescind them. Right? So it was a well-reasoned award. The arbitrator found that there were separate contracts. Breach of one contract doesn't mean anticipatory breach of the other contract. Breach of one contract doesn't mean you can terminate the other contract and expect them to breach that other contract. Right? You have to wait. So it was a well-reasoned award, and the court held that even if the arbitrator was wrong, even if he was wrong, it was irrelevant. An award could not be set aside simply because there was an error of fact or law. The court would not interfere unless the award was in conflict with public decency, behavior, morality, and or justice, or which would be an unusual occurrence. The court held that all these notions of public decency and behavior and morality, which are grounds for setting aside on the basis of public policy, these seldom occur in the commercial context. So if you look at the last paragraph, this is what the court said. I regret it does not shock my conscience. The judge said that. In short, the plaintiff made certain commercial decisions, right? They made decisions to enter into separate contracts. And even though the first two contracts were not, the payments were not made, they entered into the remaining contracts, knowing that they had not been paid for the first two contracts, right? So the court held that the plaintiff made certain commercial decisions which turned out to be disadvantageous. This is part and parcel of normal trading. There's nothing which shocks the conscience about this. The outcome is I accept stark, but this cannot turn a bad commercial deal into one that shocks the conscience, right? It's a bad commercial deal. That's what it was all about. Maybe you should not have had separate contracts. Maybe you should have had one whole contract. Right, the next case, again, a Singapore case, and this concerns gambling. the construction of a casino, the operation of a casino, Bloomberry Resorts and Hotels, and Global Gaming Philippines LLC. So the owners of the owners of a casino located in the Philippines, they entered into a management service agreement with a company for the development and operation of a casino. And subsequently, the owners terminated the agreement and the service company commenced arbitration. Now, the tribunal decided that the owners had unlawfully terminated the management services agreement and they awarded a whopping 85.2 million US dollars in damages for lost management fees to the management company. Now, the owners applied to the Singapore courts to set aside the arbitration award, and they did so on the basis that the award for loss of management fees breached or violated Philippines tax laws. They said the award would uphold tax evasion fraud in the Philippines. Why? Because they argued that the remedies award, so that the award, the arbitration was bifurcated. There was a decision on liability and then a decision on damages, which is called the remedies award. And the remedies award awarded a post-tax figure. And by awarding a post-tax figure, they argued that this would encourage evasion of tax evasion. It encouraged the fact that, well, the Philippines authority would not be honest and pay tax. And they said this would be contrary to Singapore's public policy. Now, the Singapore Court of Appeal rejected the casino owners' arguments on public policy. Again, they said to set aside an award for being contrary to public policy, there must be exceptional circumstances. And there must be a violation of the jurisdiction's most basic notions of morality and justice. The court held that there was no breach of tax laws. Nothing in the remedies award, they said, prevented the owners from performing their duties as withholding agents and paying taxes due on the award sums under Philippine tax laws. Right? Nothing in the award that would prevent them from being honest and paying the required tax. Right? If they didn't do so, there was a criminal act on their part, and they would have to bear the consequences. But the award did not prevent them from doing so. So the tribunal considered the impact of withholding tax, and the tribunal had reasoned out. They considered the impact of withholding tax under Philippines law, and again, they had a reasoned award, and they finally determined that the damages should be awarded on a pre-tax figure. Right? So, on a post-tax figure, not a pre-tax, post-tax figure. Right? Now, let's look at the next case. Now, let's move on from Singapore, and let's go on to the UK. And this is the decision of the UK Privy Council. Here, the dispute involved a contract that was entered into under Mauritian law. The legality of the contract came into question. It was challenged because one party alleged that it failed to comply with procurement legislation in Mauritius. The arbitrator considered the point, and he held that in his award that this contract was exempted from the public procurement legislation, and therefore it was not illegal. So he supplied his mind to the question of illegality. He held that it was not illegal. It was again reasoned in his own. Damages were then awarded to the claimant, and of course the respondent applied to set aside the award on the basis that there was a breach of Mauritius public policy. The Mauritian Supreme Court heard this. They recognized that the grounds for setting aside, recognized that public policy grounds should be applied very narrowly. But they decided that the award, called the Betamax Award, should nevertheless be set aside because it was contrary to Mauritian public policy. Why did they do that? They disagreed with the arbitrator's finding. The arbitrator found that the contract was not legal. The arbitrator found that the procurement legislation in Mauritius was not applicable to this contract. The Mauritian Supreme Court disagreed. They said it was applicable. This contract was not exempt from public procurement legislation. And by allowing the contract to proceed, by upholding it, there was a flagrant breach of public procurement legislation. And it was intended, the court said, to protect good governance of public funds and would violate the fundamental legal order in Mauritius. Now, appeal was made to the Privy Council. right? So Mauritius, you can still go to the Privy Council, and the decision of the Mauritian Supreme Court was overturned. Now, why did the Privy Council do that? Now, the Privy Council held that the supervisory court's power to intervene with awards on the basis of public policy was limited when it comes to was quite limited, right? Yet the Supreme Court in Mauritius was not empowered to review the tribunal's decision on illegality, right? This involved matters of interpreting legislation. So the point again is the Mauritians, the arbitrator had considered illegality. There was well reasoned in his award, and he interpreted the legislation, and he arrived at the conclusion that the legislation did not apply to this contract. Procurement legislation did not apply to that contract. It may be wrong, but a court cannot reopen the issues. This is not an appeal, right? This is an application to set aside, right? So if you look at the second paragraph, the tribunal has specifically considered issues involving illegality within its jurisdiction and set out its reasons for holding that as a matter of fact and law, that there was no illegality. That decision will be final in the absence of fraud, a breach of natural justice, or any other vitiating factor. Right? So here the court again felt there was nothing that they could do, or the Supreme Court should have done, to interfere with the award. It had addressed its mind on the issue of illegality. It was considered, and the arbitrator arrived at his conclusion. Now let's look at Hong Kong, the case of Z and Y. The matter involved a China-seated arbitration where the tribunal had made an award against the respondent in respect of obligations under a guarantee. Now, the underlying guarantee transactions involved 8 supply contracts where goods were supposedly to be sold. However, it was alleged that no goods in fact changed hands. It turned out that the supposed supply contracts were sham arrangements to disguise what were actually loans. And under PRC law, it was argued that these were fraudulent contracts, they were illegal, and they constituted a crime. Now, after the tribunal made an award against the respondent applied to resist enforcement in Hong Kong. So this was an application to resist enforcement on the grounds of public policy. And on the ground that the sale contracts gave rise to the guarantees which were illegal. The guarantee was void and invalid under both PRC and Hong Kong law, and enforcement should not be allowed. It should not be allowed because it went against the public policy of Hong Kong. Now, the Hong Kong Court of First Instance set aside the award, and they set aside the award on the ground that there was a breach of public policy. The court recognized the fact. The court said, yes, we recognize that a mere error of fact or law is not sufficient to set aside an award for breach of public policy, and that we should not review the merits. But the Hong Kong court looked at the award and they said, it's very sparse, right? The tribunal has not addressed the issue of illegality presented to it with adequate reasons. It was a very sparse award. The tribunal failed to give any adequate reason for its conclusion that the underlying debt was not illegal. Issues involving the validity of the guarantee under PRC law were also not addressed in the award. Basically, what the arbitral tribunal said is, it's just a 12-page judgment. It's quite short. You can have a look at it. But the arbitral tribunal basically just said that the evidence doesn't point to illegality. That's all they said. There was no reasoning. There was no examination of the evidence. There was no examination of PRC law or Hong Kong law and reasoning as to why they felt that the contract was not illegal. Right? So there was no such reasoning. So the court set aside the award for breach of public policy. Now, finally, let's look at the Australian case of TCL and air conditioner and Castel Electronics. Now, this dispute involved the exclusive rights agreement, a distribution agreement which gave Castel the rights, exclusive rights in Australia to distribute TCL's manufactured air conditioners. Now, disputes arose between TCL and Castel because TCL began selling non-TCL branded air conditioning units in Australia. So they started competing with Castel when Castel was supposed to be exclusive distributors of TCL manufactured air conditioners. So the matter was submitted for arbitration, and the final award of Aussie 3.5 million was made in favor of Castel. Now, TCL sought to set aside the award on the grounds that it was contrary to Australia's public policy. It argued that public policy was engaged because there were breaches of natural justice relating to procedural fairness. Now, it contended that there was no evidence that three critical factual findings made by the arbitrators, three factual findings made by the arbitrators, and that the arbitrators, there was no evidence to support those three factual findings. And they also argued that the arbitrators could not have made those findings because they had said that Castel's expert witness lacked expertise, which meant that they should have instead relied on TCL's expert witness. Right? So they argued that there was no evidence to support the three critical findings that the tribunal made. And moreover, the tribunal had expressed its view that Castel's expert was basically useless. And so TCL argued that since there was an argument that there was a finding that Castel's expert witness was useless, means they should have adopted the findings of TCL's expert witness. Now, sounds very complicated, right? Or factual. So the Australian Federal Court held that there was no breach of public policy, right? They looked at the award, they saw the arbitrators had not engaged in guesswork, it was a reasoned award. They considered all the evidence and witness testimony to arrive at a determination, and they held that this was just a disguised attack on factual findings, right? Dressed up as a complaint of natural justice or breach of public policy. So the Australian court made some comments on the model law, and they stated that there must be real unfairness, right? When it comes to setting aside for breach of public policy, there must be real unfairness or breach of natural justice. There must be real unfairness. There must be prejudice or practical injustice. Must be a case of a party being denied an opportunity to be heard on an important and material issue that could reasonably have made a real difference to the outcome of the arbitration. Right? So, and the court came up with this phrase of international harmony. It is important to maintain a degree of international harmony and concordance of approach to international commercial arbitration. The court held that national courts must harmonize their approach. That will facilitate international commerce. Right? So they said harmonization is especially germane for interpreting legal materials such as the model law that resulted from extensive negotiation and discussion by international bodies that intended to advance uniformity of approach. So in conclusion, right, has this unruly horse been tamed? Well, I think the answer to that question is it depends on who is riding that horse. Right? You need a good man in the saddle. So to mitigate the risk or attempts of setting aside awards for breach of public policy, parties should raise any relevant issues of illegality, should raise it to the tribunal. And arbitrators in our midst consider the issue of illegality, address it, reason it in court. So the conclusion is the unruly horse can be reined in through the harmonization approach in interpreting the model law and interpreting the New York Convention. And, Lord Dennings, I'll just conclude with what Lord Dennings said at Enderby Town Football and Club. He said, with a good man in the saddle, right, good judges, good courts, the unruly horse can be kept in control and it can jump over obstacles. So that's all I have. I hope the presentation has been useful. Ganesh, I'll hand it back to you for questions.
Thank you so much, Kiran, for that wonderful presentation in a capsule with a comparative analysis of not just India, but Singapore, Australia, Hong Kong. I think you did an amazing job in such a short time. Thank you so much. If there are any questions from the floor, from the audience, from the spectators, Madhu, do they ask the questions or they put it in the chat? How does it work?
They have to put it in the chat, so you've got to check the Q&A.
Yeah, okay. I don't see any question answers yet. Q&A, yep.
We can ask them to raise. Maybe
Yep.
one or two
Yes.
questions. We can unmute them if they raise their hand.
Yeah. Does anybody have a specific question? Can you please? I think Kiran, you are very clear. Looks like it. No, I have a question for you. While if somebody else is going to ask or give their views. I know it's very tough to now set aside an award in Singapore on the ground of public policy, but I think there have been instances where it has been done, isn't it? So, what in your view, I mean, do you think that using this as a ground at all is, I mean, sometimes when as lawyers, parties come to us, for if let us say they are not successful in the arbitration, they do approach us and say, what is the way? One is, of course, that the party was not given an opportunity to present the case, but that's very difficult these days. Then immediately they jump to public policy. And in India, we have reserved this patent illegality for domestic awards, which in my view is another kind of floodgate. But then I think, as you know, India is such a big market. You have big arbitrations, you have mid-level, and you have small arbitrations as well. So there is a necessity to reserve this. So therefore, I think I'm wondering, what do you think should be the, whether it is possible at all in Singapore? Has it happened any time in the last 10 years? I think there were one or two cases, I think, in fact, yeah.
Yes, there's a recent case. I can't remember the full name, but it's involved Pertamina,
Ah,
right? And there, in that case, it's now pending before the Court of Appeal, but a High Court judge did set aside the award.
is it by Cheng Hock, Justice Cheng Hock?
Yes, I think so. It was, yes.
Okay.
And basically, there the arbitrator had considered an issue and arrived at his decision based on an issue that the parties had no chance to address him on.
Right.
So this arbitrator is a former judge of the Singapore court. So I think he took the approach that sometimes judges they come up with some law that lawyers may not have been competent enough to address, and lawyers didn't think of this, and this is the answer. So what happened in that case is the arbitrator based his award on an issue that parties had not addressed him. And
Right.
that's where it was challenged on the basis of breach of national justice, breach of public policy, of course, also allegations of the arbitrator having exceeded his jurisdiction, right? The combination of these factors. And the High Court judge agreed. High Court judge said that, look, and this was not only this case, it's another case involving, I think, DBS Bank as well, where the same thing happened. And in that case, the arbitrator did not give the other party an opportunity to present its witnesses.
Mm.
So what happened in that case is the other party, was an Indian party, had not complied with certain timelines or deadlines, and it asked for, it was objecting to the jurisdiction of the arbitrator.
Sure.
The arbitrator held the jurisdiction. The arbitrator said that they said we need time to produce our witnesses, and we would like to conduct cross-examination. The arbitrator refused and said that, look, I'm just going to decide it on a documents basis. Now,
Right.
that award was also set aside.
Sure.
And that thing was upheld by the Court of Appeal. The one involving Pertamina, that one is
Still pending. Okay. Right. Thank you, Kiran. There's an interesting question by Justice Kothari, who is here. We are really honored to have you, sir, on the chat. Kiran, in India, we have new section 29A, where there's a time limit to make the award. Earlier, it was 12 months from the time, the tribunal was constituted. Now it's 12 months from the time pleadings are closed, unless parties agree for a 6-month extension or the court grants an extension. Now, Justice Kothari's question is there a time frame for arbitral tribunal for giving awards in Singapore, and is challenge to awards in court a routine affair, or is very rare in Singapore? Because you see, in India, you just do it as a course. So what is the practice in Singapore is what Justice Kothari wants to know.
there's no time limit like what you have in India. Although I think ICC does impose time limits on its arbitrators.
Right.
And whenever the arbitrators have to exceed that time limit, they need the permission of the ICC. and then the ICC often issues an extension and informs parties, etc., etc. But as far as our legislation is concerned, unlike the Indian legislation, there's no time limit. Now, as to whether or not, I would say that it's not parties don't routinely apply to set aside arbitration awards. That doesn't happen in Singapore. You often get inquiries, you inevitably get inquiries on whether the award can be set aside or whether we can resist enforcement. But in Singapore, I would say that there is not this culture of immediately applying to set aside the award.
Right.
There are in some cases, but I wouldn't say that it's a very common practice.
That's right. Thank you. Thank you. Thanks so much. And there's one other question from Himanshu. I think they will finish with this question. Should India, or is it practicable to have a separate public policy? Or should we, let's say, have international public policy for foreign awards like France has? Segregation of domestic, international public policy. This is one question from Himanshu Setia, my colleague in Delhi.
Right.
Do you have any views on that, Kiran?
I think that would be in breach of the international one for domestic. Is that what you're saying?
Yeah, one for domestic. Do we view public policy differently for domestic awards, and should we view it differently for international awards?
Well, in Singapore, there is a distinction, Ganesh. There is a distinction. Domestic awards, you can actually appeal.
Appeal, right.
If it's an important point of law or
Correct.
general public
Correct.
importance,
Correct.
right? So there's
Correct.
the difference there. But insofar as putting that aside, I think the approach is common. That's between domestic and international awards. So I think there should not be too much of a distinction between domestic and international awards.
Yeah.
But in Singapore, we do have that exception.
That appeal on, yeah.
You mentioned France. France is quite unique in the sense that they can even, I think in a recent case, they actually enforced an award which had been set aside at the seat of the arbitration. You know?
This is the two bites at the cherry theory, which has been going around, where they're arguing whether because of the New York Convention, you can do it in one jurisdiction or not the other. So I think
on the French court, I think in a very disguised judgment said that they really didn't consider that setting aside, as being very credible. So
right.
They allowed the enforcement of the award.
Sure. In fact, in India, there is a little bit of a distinction because we still reserve patent illegality as part of the set aside provisions for domestic awards. So I think that subtle thing is there, but it's of course separate, not exactly under public policy, but it's patently at a separate ground. But anyway, on that note, it's already 6, and it'll shock our conscience, Kiran, if we keep you further, because I know you have another meeting. So I
can spare a couple of minutes if there are any other questions.
Sure. I don't see any other question. So may I request Madhuri to propose the vote of thanks. And thank you so much, Kiran. Look forward to,
Thank you very much.
Thank you, Mr. Kiran. At the start, you said you did actually, keep up our hopes, and it was a fantastic session to have, travel from India to Singapore, as Mr. Chandru said, to, all over the country, all over the world, looking at different scenarios. They say that public policy is an unruly horse, and I like the way you ended it with the positive note that the person, who's a good person on top of it, you will be able to manage it. I hope it's not an Achilles heel anymore for anybody, and that, we'll be able to go as we go by. So it was a very wonderful webinar. I think Dr. Vineet Kothari also agrees to it, and he also posted a chat. So I would also like to take an opportunity to thank him for being here, because he's one of our wonderful judges who was in Madras High Court. And he has, passed some very good judgments on the public policy itself, and he's presented a paper and written articles on how foreign arbitral awards are all to be enforced in India. So it's a pleasure having him. Mr. Singh, we are also actually looking forward to have you in a different, perspective as well in our MAMC. We're looking forward. We'd like to thank you for taking your time off and coming and participating in this busy schedule. Mr. Chandru, as ever, it was fantastic to have you here and, to have coordinated the entire thing. And, such a, I wouldn't say a technical or, in the policy, the public policy itself is a very, very wide subject. And, you were able to get the topic right and, actually face what it was, what we're looking for here. So thank you very much for coordinating this. and being a moderator for this session. Thanks all the participants who participated in this, taking your time off, and we look forward to see you all in your next sessions that we'll be organizing soon. And it's a wonderful, to have you all here. Thanks, Madhu, as usual. It was wonderful to have, coordinated it very well, and all Ms. Saraswati and all the other MAMC members. So thank you all. Have a very good evening. Thank you very much.
Thank you.
Thank you. Thank you, Mr. Kiran. Thank you, Ganesh.
Thanks a lot.
Thanks.
Yeah.
Thank you so much.
Bye.